Can you trademark something that's AI generated? Does the fact that a human didn't create something like an animal character that you've created with the help of AI and want to use as part of your brand mean that you won't be able to trademark it? Welcome, I'm Shireen Smith, brand lawyer and founder of Brandtuned. Subscribe to this channel for videos about business design, managing competition, using intellectual property, and other ways of increasing your brand's success. Here, it's important for me to mention that there's a difference between copyright and trademarks. They're both intellectual property rights, but they're each subject to their own unique rules and protect different aspects of a business. I'll be doing a video soon on both these rights and what impact it would have on you if you didn't own the copyright in something you're using. So be sure to subscribe and hit the notification button so you're notified when I post a video here. While the copyright position of AI-generated works varies from country to country and involves some complexity, the trademark position is relatively straightforward and clear-cut in most jurisdictions. So that's what I'm covering in today's video. Trademarks are the signs, such as your name, that identify your business and distinguish you from other businesses. The starting point with a trademark is arguably not its creation, but its adoption and use, or proposed use, in connection with the sale of goods and or services. It really doesn't matter how the trademark comes into being. So, if you create something like an animal mascot with the help of AI, there is no issue whatsoever for your business to use and trademark it. Nor is it necessary to prove that the asset is distinctive. What's distinctive about the 3 stripes that Adidas has made famous as its trademark, for example? The EU courts have described them as utterly banal. The key issue when designing something for trademark use is to avoid descriptiveness, because you won't be able to trademark something that's too descriptive of the business's products and services. For example, say you run a pizza cafe and decide to create a mascot that looks like a pizza. You may well have a problem owning trademark rights in a mascot that looks like a pizza, regardless how distinctive your pizza mascot looks like. It would be too descriptive of your products and services to qualify for trademark status. It's a ridiculous example, I know, but I give it because people so often make the mistake of opting for descriptiveness, descriptive names or symbols, without realizing that unless there's something really creative that elevates a name or sign beyond a simple description of your products and services, it just won't be effective or ownable as a trademark. To own trademark rights in something, it must be unique. So if you call your pizza takeaway Fresh Pizzas, you're using a descriptive name that isn't unique enough to own. But if you called it something more inventive, like Pizzas Are Us, that is more unique and hence possible to own. You'd be able to trademark it, assuming nobody else owns rights over a similar name. So creating a strong, protectable brand requires joined-up thinking, whereby IP is considered before and during the creative process, be it a name or visual or auditory sign that you're designing. That's the best way to avoid designing something you believe is distinctive from a visual perspective, but which the law would regard as descriptive. So, in conclusion, you can trademark something like a character that you've created with the help of AI. The use of AI won't affect your ability to own the character as a trademark. What matters with trademarks is what you trademark in connection with the sales of your products and services. I hope you found this short video explaining the approach of trademark law to AI-generated content useful.